And it's again, it's something that's going to come with how society gets used to this issue, because when you're dealing with drugs regulated by Health Canada, they go through a very rigorous testing process in order to get approved as a drug. And marijuana hasn't gone through that process because it's been illegal to do testing with it for however many years it's been unlawful. And so in this particular case, it was a case decided by arbitrator Brian Sheehan here in Ontario. It really had to do with the minutiae of the contract and the policy language. It's the policy itself said in order to get paid, you needed to have a specific ID number for the drug for it to be paid for under the plan. And because, there's no marijuana ID number, too bad, so sad, it's not covered, and you're just going to have to buy that on your own, or I guess grow it in your backyard. But it will be an issue that's going to come up when we're negotiating benefit plans, if it's something that's of interest to the memberships. I don't know how many people in each of your memberships is going to be affected by this too, right? It might be a very small percentage. You got a hand over here?
Yeah, it's one thing, collective agreements is a good way to put that stuff in, but if you have the regulator implementing it, like because of the Canadian Nuclear Safety Commission, last year they're bringing in regs for fit for duty, and they include drug and alcohol. Well, they took a broader brush than that. They did psychological testing and medical or prescription drug testing, and now we're hearing financial checks are coming down. The thing that threw it off in the ditch, because there is no drug testing other than just cause in the nuclear industry, is the fact they had the psychological testing and the directors put it on pause because that's something they're trying to wrap their head around. It's another thing that came out of the States. So this is evolving, and it's only because they took a broad brush that we didn't have it in front of us right now, but when it's regulators putting it in, it's pretty tough to put collective agreement language in to protect yourself. So I don't know what your thoughts are on it.
Every negotiation is different, and all the priorities and all negotiations are different, right? So it's something that, depending on the needs of your membership, it might be hugely important, or wage increases that are at least what the consumer price index provide might be more important. That's going to come up.
To be fair, all the unions and the employers have submitted briefs.
Yeah.
And even the employers said, let us work it out with our workplace partners. Don't put something over us that's going to cause the industry problems. Let us work it out first.
Right.
And then we'll tell you what the regs should look like from a collective point of view. They didn't choose that process yet.
Yeah.
Anyways.
Question over there?
I think brother over here addressed my issue with about creating language. Case law, the regulators are going to override or supersede whenever we would come together. When I see the CCU's role, and this is exactly what's happening today, is educating all of us on
I'm not saying we need language in a collective agreement, but I expect employers to want to do things too, and maybe we resist against language. I don't know.
Chances are we may already have language. I know.
Yeah, exactly.
What I'm thinking of, it's a human rights violation against a disability type thing. So that would be.
But it's not going to be a disability issue.
It's a medical issue, and it's a medical prescription, which comes down to, in my opinion, it's dealing with somebody's disability.
But it's 75,000, and in August or whatever, it's going to be 20 million.
And it's going to be the same. It'll be the same. I think it's against disability. I don't think new language is going to change no matter how many more people there are.
But when it's legal, it's not about medicine anymore.
No, but so my next point though is also hasn't been addressed, and I'm assuming it'll probably come up. We've heard about Oxycontin, and we've heard about alcohol and marijuana. To me, I think the biggest difference between the first two and the last one are the first two are measurable. The impairment levels are measurable. Where right now there isn't a way of measuring the impairment level of marijuana. And that's really the biggest challenge. So you can be prescribed marijuana, but at the time of if you're dealing not just with in the workplace, but if it comes down to an accident and you're tested for a workplace accident, your level of impairment on marijuana can be measured accurately at that time as it can be with alcohol or Oxycontin. So now it's a matter of the doctors prescribing it. And now if you exceed that dosage, that brings you to a level of impairment, which causes an accident. It's a different measurement than the marijuana, where you can't tell them if you smoked it to come to cost before night, before you went to bed, or if you smoked it instead of lunch. So those are other challenges.
No, that's a huge challenge, and that's going to get into what I do want to talk about next, which is drug testing. Flip me over here. Okay, I got it. So drug testing in the workplace has been something that got really hot in the case law about 3 years ago, but continues to be something that I think is going to come up more with marijuana being legalized. I don't understand the science. I'm not going to claim to understand the science about testing marijuana itself, but there seems to be some progress made in the area. How reliable it is, it's very, it's difficult to say. I've dealt with a few cases where employers go and they get this this expert report from this guy in the States who says, if you smoke a joint, it's going to have an effect on you for many days, which my friends tell me isn't true. To the degree of impairment, if you go out and you drink too much, you're going to be impaired the next day. And my assumption is if you smoke or take cannabis too much, there's also a possibility you're going to be impaired the next day. But the level of impairment and how you can measure it is really going to be an issue. That gets us to sort of drug testing and the law around drug testing as it's developed in Canada. And for many years, in this room, it would be really difficult for me to tell you how it worked because we had a way it worked in Ontario and it didn't necessarily work that way in BC and it didn't necessarily work that way in Alberta. But that's somewhat been clarified since. In 2006, there's a decision out of Imperial Oil that was eventually upheld by our Court of Appeal. And it set out what's been now sort of called the Canadian model around drug testing. The union was challenging this drug testing policy in Ontario Oil. It's called the Nanticoke case. And in that case, you had a policy of the employer to allow for random, unannounced drug tests. And they were using oral swabs to try to detect cannabis, including alcohol, including trying to detect actual impairment. And the union said, look, this is unreasonable. I mean, you don't need to be invading our privacy to this degree with such a policy where people who have never used any type of drug in their life are pulled into a room and told to open their mouths and have saliva be attached to swabs that then get tested, and you have your complete credibility challenged through this whole process. Remember, with these things, it's not the guilty people that are affected by it, right? It's the people who should never have been tested at all, that their dignity is put in question. And in this case, and the next one I'm going to talk about, the facts were really good for the union because there actually hadn't been any evidence of a problem. And just keep that in mind, because what happens is that the arbitrator, and this eventually gets upheld by our Court of Appeal in Ontario, says, no, you're not allowed to have a policy of unannounced random drug tests. Even in this Imperial Oil environment where it's an extremely sensitive or safety-sensitive environment. And part of the reason that swayed the court and the arbitrator was that, what's the issue here? What is this policy reacting to? And they didn't have any evidence that there was much of a problem. That said, that's the good part of the case. The other part of the case is it actually clarified when employers can test. And that's what's led to many of the policies you folks have probably had to read when the employer tells you what their drug and alcohol testing policy is. The one is if there's just cause to do so. If somebody comes in and their eyes are bloodshot and they're slurring their words and they, look impaired, the arbitrator and the courts have said, yeah, it's perfectly reasonable to test you. And I'll tell you, as somebody who works with unions in safety-sensitive environments, it's pretty hard to argue against that. Nobody wants somebody impaired working with them. The second is when there's an incident. Somebody crashes the truck into a pole. The arbitrators have said, yeah, if there seems to be some basis for doing so, employers can test. The third one area that I think is a bit more troubling is when you have an employee who's disclosed an addiction or has had previous addiction issues in the past and they're brought back on some conditions. And arbitrators have said that's okay. It's something I've always felt pretty uncomfortable with. You have somebody who's disclosing a disability is recognized under the Human Rights Code, and they're saying, okay, well, you can watch me for a certain amount of time. One of the keys for you in that circumstance where drug testing is allowed, including sometimes random drug testing for such people, is that you're going to be involved in negotiating that. If they don't involve the union, the case law's a little bit up in the air as a result of a couple cases recently, but if they don't involve the union, you should be trying to challenge these programs if they're brought in for a particular individual who's had a history of this. If they haven't talked to the union to try to negotiate something, that's something we should try to be involved in, and if we're not, then challenge it. Mike?
So I assume that the employer can't start a drug testing program, et cetera, without informing the employees that this is their new policy. Is that correct? Or
I think it had. He just said.
Mike, I love it when you say, can an employer do this?
yeah, I know they'll do it anyway. Yeah,
Yeah, they can. Of course they can. They can go do what they want.
But will
The answer is, can we do something
Right,
about
well,
it?
it's
Well,
a
once you do
box,
something
right.
about it, what the first thing you do, that doesn't even have to get to me, right? The first thing he needs to do is say, we got a policy, shoot it out to the membership. Because the last thing you want is them to get disciplined, and then you have to sort of work it out there. You want them to know. You want employees to know.
So the employer really, if they're making a policy about drug testing, they have to let the employees. They should let the employees know.
They're going to want to do that, right? Because if they end up disciplining somebody under the policy, they're going to want to be able to lead evidence that says he or she knew about it. Right. And if he or she didn't know about it, then it makes their case a little bit harder, but I wouldn't say it gets us totally off the hook either.
Okay.
Yes?
So you mentioned the first possible reason why an employer could ask to have a test done, and that's because the employee looked like they were intoxicated, like they seemed to, is that?
Yeah, it's reasonable
do you not
cause.
have a problem with that, or does that seem reasonable, or what?
It's always dependent on the circumstances of the case, right? When, from our point of view, we're going to be wanting to look at how did you, employer, what factors did you consider in making that decision? And that's where I would say the employers have to be a bit more careful, because, they need to be able to point to some facts to say, we needed to test this person. That I smell bourbon on it or something like that.
Could it be one incident? Could it be over a period of maybe 2 weeks where, how did they make that decision? I think this employee is, coming to work intoxicated. How do they?
They're going to have to point to some factors, factual factors. He was slurring, I could smell alcohol, he wasn't paying attention, he fell asleep when he was supposed to be working. Is something factual to base.
The employer would have a built-up.
Well, and I just heard from Sandy, that could be someone who's diabetic, and it's true, it could be.
Be so many other things other than.
But what the case law says is they're allowed in that circumstances to invade the privacy. They need to have a factual basis for doing so. And whenever I say they need to have a factual basis, I should have said this at the outset, it's kind of code to you of you need to be inquiring about what that factual basis is, because that's how we police them and that's how we prevent them from targeting people without factual basis, or even worse, targeting people based on things that they shouldn't be considering at all. You know, young people probably get tested more often than older people, and I wouldn't doubt that persons of color get tested more than persons who aren't of color. And those are the things we got to be watching out for, to make sure that they're not considering irrational or unreasonable factors as well.
So from a lawyer's point of view, you would look for an employer who has already documented incidences where this is why we decided we would test this person.
Yeah.
You know, because they did this.
Yeah. I mean, I'll be honest, I haven't seen very many simple reasonable cause incidents. I have heard of incidents where somebody comes in and somebody else who's an employee says, "You're looking kind of sick today. I think you should go home." And that's what happens, and that's what maybe should happen. Nobody wants to work with somebody who's impaired. The ones I do see more often are the post-incident testing, which Imperial Health, the case says you can do, or an employer can do. That's, really tricky, right? If there's an incident and it's because the tire blew out on the truck, well, that's because the tire blew out on the truck. That's not because we thought the guy was drunk, right? So we have to be policing that as well. But arbitrators are going to give employers leeway to do these things because of the safety implications.
And probably like Molson's would have some kind of policy, where at lunchtime, like if they're giving them free beer or something. They would probably have some kind of policy. No, I mean, they do that with your breweries,
Yeah. Yeah, I mean, that's going to depend as well. But, I saw, was it Mike?
I'll just make a quick comment. I know at previous CCU meeting, people were talking about non-reporting of things because that would be an incident trigger, and then people would be looked at more closely, possibly tested, depending on. So people won't report an incident because they don't want to be put the red flag on me.
Well, like you've heard me say it before, some of you have. I mean, management has management rights. It includes the right to manage the workplace poorly.
Right.
Just because because managers are allowed to have these policies doesn't make them a good idea all the time. I think you want to create an environment where people aren't not disclosing things for worry that they're going to get caught with something else. It's the nature of being a difficult issue, right? There's no easy solutions to it. And you're not going to get me up here saying they shouldn't have any policies at all. It's trying to create that balance. That's hard. And that's why they should be talking to us about how to do that, right? How do we negotiate a balance here that's going to bring that perspective? Because in my view, managers don't think that way a lot of the time. They think, how can we wield our power here?
Right.
How do you handle companies that have a drug and alcohol policy, and it's usually happens around an incident that will trigger that? So in the findings, they find THC in the person's system. So you talk with the person, and they say they haven't smoked a joint for at least a week, which brings up the question: THC stays in your body a lot longer. It had nothing to do with the incident, but now all of a sudden this person is highlighted. And they've got them on a piss test for every once a month for a year, and that's the problem we're fighting with right now.
Yeah, and
It has nothing to do with the incident or accident, but because of the nature of the drug stays in your system longer.
And it's a big problem because the science isn't there yet. Because it's not as much of a legal issue as it is a science issue. And so there's very varying research on how long it stays, not just how long it stays in your system, how long it causes impairment in your system. Because it stays in your system a long time. And for reasons I can, as a professional, can understand, doctors are really reluctant to come to the support of the people who have it in their system. It's an easier and more conservative approach to say, let's be cautious here and keep this person out of the workplace if it's in their system at all. The case where I have had that come up, it didn't end up going to total litigation, but the expert reports that come out say this stuff can keep you high for a longer period of time than anyone thinks. Or not high, but impaired, right? One of the things, when we were prepping that case, we were trying to think of how to address that, and you have to, what we sort of brainstormed around was comparators, I got up at 5:30 this morning because my son had a hockey game. How does that affect my performance today? I was up late last night I worked the night shift last night, and the manager wants me to work at 11 o'clock the next morning, get overtime because he needs me in. He's told me I can't refuse it. How does that affect my performance? There's a lot of other things that affect our performance in the same way, and it's trying to find that balance where we can recognize there's things that are unacceptable, but also be reasonable about the actual, real risk that it creates in the workplace.
Well, we're grading it, and what they come back with is an alternate policy, which now includes this swab test, and now they say they can tell within how many hours you've actually induced.
Yeah.
If they do find THC, they can tell whether it's a week ago, a month ago, a day ago, 4 hours. I don't know whether to believe that or not, but they say they
and
got it.
I don't either, because I keep hearing different things from different people
This is from British Columbia.
Yeah. So part of it is, there will be, with the legalization, I anticipate there will be some refinement in the science. I assume that when we started to do roadside alcohol tests, at first they probably weren't very good. And that's going to be the same here. Right? They haven't.
Right now, I got members subject to their strict policies, which they've got to supply a piss test twice a month for the first 6 months, and then once a month for the last 6.
Yeah.
But the company can stop it at any time if they think you hit the mark.
Yeah, and that's the other thing you have to keep in mind when you're dealing with members in this situation. It's what I call piss now, grieve later. Because while our society is working all this stuff out, you have to apply the standard principles of labor law, which is that if manager tells you to do something, you do it now, and then you grieve about it later.
Yeah, no, he's doing it.
And yeah.
It's a condition of employment.
Gerald, what triggered the incident? Or what triggered the drug test? Was it
A lockout. Lockout
a
infraction.
lockout infraction?
And that's enough to, police it or not, yeah, you weren't, what were you thinking? You knew you were underneath that conveyor of change. You should have, everybody knows you got to lock out, de-energize.
Was it pushed by management, or was it pushed by?
Pushed by management. Once, as he alluded to, it gets to the higher up in the company, they have no choice. Sometimes you can sweep it under the carpet at a low level, right? But as soon as it gets into HR and up in management, away she goes for the ride.
Yeah.
Okay, a lockout. Okay.
Well, very dangerous if you don't lock out properly, right?
Oh, I know it's very dangerous, but it's not something that always indicates that you're impaired,
Exactly.
right? That's the
Exactly.
connection.
But and this is the fella who went to Sunfest a week earlier, which is a big, festival out our way on the island.
I've heard my friends tell me.
Yeah. And a week later he gets caught with THC in his system, which had nothing to do with the incident.
So just to add a little bit,
Yeah.
I don't know what it's like in the rest of the country, but in BC, they're not, the employer's not necessarily accusing somebody of impairment. They're accusing, they're checking somebody's fitness for work. So they'll say you're unfit for work. So it could be, like Don says, it could be diabetes, but they're going to rule out that it was this to confirm that it was that.
What's the difference though between fitness to work and impairment in their analysis?
In their analysis, yeah, it's subjective. It is like what Don brought up, where they look being diabetic.
Right.
They're saying, well, you're unfit for work, so we need to test what your fitness for work was at the moment of the incident. And that's actually that's work safety C language. It's the employer's responsibility to test each employee's fitness for work before they start their shift.
Right. With a drug test? Or with
Just a fitness for work. So if they feel you're unfit for work,
yeah,
then they have to determine what's causing you.
Just a visual, is it heard?
Yeah, visual inspection.
Yeah, well, that applies anywhere. Yeah.
What a refusal.
Since you guys
Next slide.
reading my notes here. No, that's dealt with in Imperial too, right? And like I say, piss now, grieve later. It really sucks. It's an invasion on your privacy, on your like they're sticking stuff down your mouth, for Christ's sake, right? It is a real invasion, but the cases generally recognize that refusing or failing to undergo an alcohol or drug test, it's viewed as a serious violation of the policy, and in itself can be grounds for discipline as insubordination, right? And it goes back to that. I mean, it's a lot of arbitrators and employers. It's listen to what we tell you to do and do it, and fall in line. If you have a problem with it, that's what the grievance procedure is for. But just as an aside, when you're in law school and you read about labor arbitration, it's described as this really quick, efficient system of justice, right? And you read some of these cases from the 50s, and you look at them and you're like, okay, this case, it's a grievance dated December 10th, and the case is released December 17th. And it literally is, they file the grievance, they go through a very quick grievance procedure, and they call an arbitrator in, and they don't have me and some Bay Street management lawyer there. They have the union rep and the management rep talking to the arbitrator and saying, we got a problem here, can you fix it? And the arbitrator writes a 2-page decision that says fixed. And it might go one way and it might go the other way, right? So it's very quick. Grieve now, or work now, grieve later, works really great in that system because, I just make it anything. It's an overtime claim. Well, okay, I got my overtime. Or, okay, I was told I don't get overtime for that shift. Happens really quick. Now we're telling people, okay, do the test, file a grievance. Employer says they're not available to meet next week. Okay, we'll meet them next month. Oh, they ask for another extension. Well, we have to be reasonable, so we can give them an extension. It's the next year now. They give you a 1-page letter that says grievance denied with no facts about why they're actually denying it. And we go to the next stage of the grievance procedure, and we refer it to an arbitrator who isn't available for another year. And then, again, it's my calendar, his calendar. And I'm not saying I love doing the work. But the system itself has imported many delays, and we're stuck with law from the 50s and 60s where things were a lot faster being applied to this system now as it is with the delays inherent. The law is not going to change just because it annoys me or you, because there is a reasonable basis to it, but it's damn frustrating for the people we represent. So I can go on. I said earlier that there's sort of there was inconsistency in the case law. That was sort of worked out in 2013 when the issue went up to the Supreme Court in Irving Pulp and Paper. And there the Supreme Court, or at least a majority of members on the Supreme Court, agreed with the Ontario approach that we've been talking about in the last few minutes, completely affirmed the situation. So they said, no, you're not allowed to do, unannounced random drug tests. And that was I can't take away, that was a great win for unions, but also affirmed all the circumstances where they could do drug tests. The post-incident, the just cause, and as part of a plan of returning to work for somebody who's had a substance issue. The thing about it too, though, is that whenever you win, you always have to read the case as, is this actually just giving management a bit of a guide on how to actually deal with situations? Because the facts of the case really influenced why the court said no random unannounced tests. They had this system in place for a while, and there actually were only 8 findings within a huge workplace, only 8 findings where there had been a positive test. When the actual policy was in place, they didn't find anybody. So there had been like 8 incidents over the course of since 1991, and then when they put the policy in, they didn't find anybody had violated it. So it's sort of the court saying, like, if you're going to say it's reasonable to have randomized testing, you're going to have to put forth evidence to show that there's a reasonable basis for doing so. So if an employer did put forth evidence that they had a drug abuse problem in the workforce, there is a little bit of a crack there for them to bring in one of these policies. You shouldn't read it as a complete prohibition. But if there's a problem with people coming to work high and doing drugs in the workplace, and that's something we're interested in as well most of the time anyway, and that's probably why it doesn't happen. Very quickly, Mike, you asked earlier, can they do this, right? And so we have this law, we have the Supreme Court weigh in, they say you can't do unannounced drug tests, and it's so crystal clear, of course, and then the Toronto Transit Commission just decides to do it anyway. Right?
Right.
So that we had a case, and people here, I mean, there was a lot of news about it in Toronto because they just did it anyway, right? And then they go to court, the union, ATU, goes to court and says they want an injunction, like, stop this, we've grieved it, we're in the problem. Chris was talking earlier about all the delays in the grievance procedure, we're going to ask for this remedy that it be completely struck down, but like, come on, court, help us out in the interim because we have members being subjected to these randomized tests. And the court says, well, we have to do the test for an injunction and you don't meet it. So right now, I don't actually know if anything's happened with the grievance, but right now the court would not intervene to stop this test. They said, leave it for the arbitrator to figure out. In the meantime, piss now, grieve later. So that's kind of where we are with drug testing. It's coming up because of, I think it's more relevant now because of what's happening with marijuana. But subject to, any more questions, I'm probably going to take a short break maybe and then move on. Of course.
I'm just wondering, do you anticipate, because I know some of the affiliates have mentioned this before, but do you see a push from the employers to get language in collective agreements?
Well, I hate to tell these people my secrets, but see, management rights, every collective agreement has a management rights clause, and it's really broad. It's only going to be limited by what we negotiate to limit it. And so I wouldn't say that the employers are going to start coming to the table to say, hey, can we get this in our agreement? Because they already have the powers to regulate it now. I doubt we're going to see much that's specific to marijuana use. The health and safety laws, the employer's abilities to bring in reasonable policies are probably enough. I think where we're going to be having to watch it more is just how they're applying it. And that's not a high-level policy discussion. That's not a what does the collective agreement say. It's what's the employer doing and how are we asserting our members' rights about those specific circumstances. I think what you're going to see is in more testing. Mike?
One quick comment about the swab testing. I'd be very careful about limiting what actually they can test from the swab testing, because from the swab, cheek cells, you can get your full DNA.
Yeah, but they'll say they're not looking for that.
I know,
Find it.
I know.
But they can find it if they want it.
One more quick question, Chris. One more and then we'll break it. From Jan?
I can take questions all day as long as you guys have.
Take a break.
I just got one comment and a half question. So, for the marijuana debate, okay, they're going to legalize it here sometime in the next year, right?
Mm-hmm.
And I was speaking to, there's this notorious management lawyer in Alberta, David Ross, Colin and Ross, and they're the ones who are actually pushing the signboard industry. And I was talking to him about a week ago, and we had a really frank conversation around this issue. And he was like, okay, they're going to legalize it, but they're not going to, have any regulations. They're not going to say that this is the legal test for impairment, this is what constitutes impairment in the workplace. And I know I listened to Anne McClellan there, who was heading the federal task force on the legalization program. And she just said, well, look, we're going to let the labor board, the compensation boards, the human rights tribunals, they'll come up with the rules. And even the management lawyer was incredibly frustrated by that, because he's like, it's going to be another 10, 12 years of litigation after they legalize it before anybody really knows what the rules are.
It's true. It's going to provide a lot of work a lot of work for me. I mean, that's a problem that probably was made in 1867, right? There's a separation of powers in terms of what the federal government can regulate and what the provincial governments can regulate. And what the federal government's doing is getting out of the criminal law business when it comes to marijuana. And once you get out of the criminal law power, then it likely will trickle down to powers the federal government doesn't have, and the provinces each have. And, it's going to take a while. So it's not untrue. I'm surprised he's worried about it, though. He sounds like he's going to get a lot of work out of it.
Yeah, it's just going to create uncertainty and unnecessary litigation.
Yeah. Yeah.
And he's got.
Go ahead.
He didn't really have a question, right?
No, yeah.
So is the federal government going to look to the U.S. for setting laws?
Oh God, I hope not. Well, maybe. Maybe
They're already established. Some of the states are already established.
I had thought that they had sort of already looked at some of those models. I'm not an expert on the actual regulation of what they decided. I had thought they sort of looked at some of those models and have decided to do other things. But each province also has to decide how they're going to regulate it, right? So here, the most recent I saw was Wynn was going to have these LCBO type dispensaries.
And I'm going to be speaking about off-duty conduct with a particular focus on social media use. And maybe a little bit about criminal convictions as well at the end, time permitting. And there's a lot of similarities actually between this topic and the alcohol testing issue, in the sense that you're not often going to see language in collective agreements specifically dealing with social media and freedom of expression and stuff like that. It's often going to come in the way of policies and management rights, and the question will be, was it a reasonable exercise of management rights? Is it a reasonable policy in light of the specific kind of workplace, whether it's public-facing or more anonymous, the kind of work that people are doing? So the starting premise for this discussion, I'm just going to quote from Brown and Beattie, the leading labor arbitration text, is that arbitrators have always drawn a line between employees, this is quote, employees' working and private lives. They often make the point that employers are not custodians of the characters or reputations of their employees. And so the basic rule is that an employer has no jurisdiction or authority over what employees do, including where they live. Apparently that's been an issue in some cases, outside working hours, unless it can show that the employer has a legitimate business interest that is affected in some way. So the starting rule is that everyone has a private life, they're entitled to a private life, and the employer has the onus of establishing that somehow that private life has started to have implications for the employment relationship. And so employers certainly don't have a freestanding right to police the personal lives of their employees, but they do have certain legitimate interests regarding off-duty conduct, and they can impose discipline in respect of off-duty conduct up to and including termination. Actually, I should note there's often a question about whether conduct actually was off-duty or not. For example, if you have a work-related social event, a manager has a birthday party at a restaurant, is that a work event or a social event? So that's also a threshold question, because certain events that maybe seem like they're more casual or more social are still actually work-related. So that's something to keep in mind. So some of these legitimate interests that employers have include reputation, obviously, and there's a question about, well, how far can you go to protect that reputation, but certain types of conduct and comments outside the workplace can have the effect of causing a business to lose customers, lose money, lose contracts. There can be material consequences for comments that employees make outside the workplace, and there is, possibly a legitimate link there between the off-duty conduct and the workplace. So reputation is probably the main thing, and that includes both the concrete sense of, well, we lost a contract, and a more general sense of, we've spent all this time fostering a certain type of identity that we want to put out there to the world, and we don't want to be associated with certain types of conduct. There's also an interest in workplace relations. And so this is one of the things that comes up in the jurisprudence, is that maybe something that someone has said or done outside the workplace could be an issue for coworkers not wanting to work with them anymore, or not feeling safe, or not feeling comfortable working with a colleague because of the things that they've said or done. That mean, when you go into work the next day, are you going to be able to feel safe in that environment? And it also comes up in other contexts that we aren't actually focusing on today. I'm sure everyone's heard of examples of employers relying on a Facebook photo of someone at the beach when they said that they were sick that day. So it comes up in that context, and that's more of an evidence issue about, well, were they sick or not? It's not the focus of today's talk. There are obviously a few main reasons why this has become a more significant issue in recent years. The main one is simply that it's a lot easier for employers to find out what employees are doing in their personal time because of social media, Facebook, Twitter, etc. Actually, it was funny preparing for this, reading some older presentations where people make a point of defining Facebook. It's a Web 2.0 technology. And, there's all of this interesting commentary from arbitrators as they're struggling to understand, what is this new platform? What is Facebook? What is Twitter? And perhaps more importantly, it's a lot easier for the rest of the world to find out what people are doing in their personal lives. That said, these are not new issues. One of the leading arbitration cases on off-duty conduct is from the 1960s. And one of the examples that I'm about to describe is from the turn of the last century, from the early 1900s. So to start with two examples, I guess I have one picture slide. Drag over, maybe? There we go. Oh, actually, maybe we'll talk about that example, but before that, we're going to start in 1918. I love this case. There's an Ontario Court of Appeal decision from 1918. So this doesn't have a direct implication for you. It's just kind of funny. 1918 decision called McPherson and the City of Toronto. Mr. McPherson was a member of the Toronto Fire Brigade, who, in the words of the Court of Appeal, quote, is a young man not living with his wife, and he had living with him the wife of another man, a comparatively young woman who was separated from her husband, separated, not divorced. Someone complained to the fire chief about this, and the chief gave Mr. McPherson an ultimatum. either she moves out or you lose your job with the fire brigade. And he didn't want to kick her out or move out. And so the fire department fired him. And then I guess it gets even better because the trial court and the Court of Appeal upheld the dismissal. The court found that, again quoting, his employment was one in which only men of good character and conduct should be employed. And so there's obviously a lot going on there, what good character and conduct means, and the job requirements of fighting fires, about who you're living with. And this kind of highlights one of the significant points about this off-duty conduct issue, is that it really changes with the norms of the day. Things that reflect poorly or considered to reflect poorly on an employer were a lot different in the early 1900s than they are today. And so moving ahead to another example from 2013 that I'm sure many of you have heard of. Does anyone remember the name Justine Sacco? You probably heard of her, but might not remember the name. In 2013, so about a century later, Justine Sacco worked as the Senior Director of Corporate Communications at IAC, Interactive Corporation, which is an American media and internet company that owns the Daily Beast, a news and blogging site, Vimeo, the video hosting site, OkCupid, and other dating sites. So she's in a communications role. She's Director of Corporate Communications, and she works for a media company. So this should already sound pretty ominous. In 2013, she was flying from New York to South Africa to visit family members, and she starts tweeting about her journey to her 120 followers at the time. There are some innocuous quotes. Innocuous initial tweets. Weird German dude, you're in first class, it's 2014, get some deodorant. Inner monologue as I inhale BO, thank God for pharmaceuticals. Next tweet, chili, cucumber sandwiches, bad teeth, back in London. And then the fateful tweet, going to Africa, hope I don't get AIDS. Just kidding, I'm white. She tweets this just before she gets on a 13-hour flight to her 120 followers. And then a few people start to retweet it and comment on it. And then some more people retweet it and comment on it. And by the time she lands, her name is the #1 trending topic on Twitter worldwide. It's been retweeted thousands of times. So some sample comments. How did Justine Sacco get a PR job? ? Your level of racist ignorance belongs on Fox News. And her employer, IAC, tweets, this is an outrageous offensive comment. Employee in question currently unreachable on an international flight. And then a hashtag starts. Hashtag, has Justine landed yet? She lands in Cape Town, turns on her phone, and, like I said, learns that she's the #1 trending topic on Twitter worldwide. So she was then fired within a couple of days of this incident. Interesting side note, she actually returned to IAC this year, 4 years later, so they took her back. And so 2 comments about these 2 examples is from a century apart. One, it clearly depends on the social norms of the day. What type of conduct affects the reputation of the employer? Today, living with someone who is married to someone else almost certainly wouldn't result in discipline. And assuming you could tweet in 1918, probably tweeting about AIDS in Africa wouldn't result in any discipline, right? And the second point, actually, is that both of these situations probably would have been different with a collective agreement and union protections. These were both non-union employees. So that's just some scene setting of the types of issues that have arisen over time. So getting into the substance, the first point to make is that, and this is similar to the marijuana question, is that marijuana is not actually different from all of these other drugs. It's not, in substance, it's not different from dealing with alcohol and oxys and stuff like that. And so off-duty conduct, it's fundamentally the same disciplinary framework as for other types of misconduct. There's still a just cause standard for discipline. That doesn't change. An employer needs just cause to discipline an employee, and the question is whether the off-duty conduct gives rise to just cause, which involves establishing a nexus between the off-duty conduct and the workplace. So the arbitrator will in every case need to assess the same things that they assess in all discipline cases, including the seriousness of the conduct, the length of service, whether it's an isolated incident. Is this someone who has a Twitter account that's just a constant barrage of racist comments, where they just had one bad day, said something really stupid that was out of character, and that was it. So these same questions that get asked in every discipline case have to get asked in the off-duty conduct cases. I already mentioned that sometimes there's a question about, well, was it even off-duty in the first place in terms of social events at work? So, like I said, in every case, the employer has to establish some kind of link between the off-duty conduct and the workplace, or that its legitimate business interests are affected in some way. And the leading arbitration decision, like I said, is from the 1960s, the 1967 decision in Millhaven Fibers and the Oil, Chemical, and Atomic Workers International Union. The arbitrator set out 5 factors to be considered in off-duty discipline cases, and these are ways of linking the conduct to the employment relationship. So first, there's a nexus, there's a link, if the conduct of the griever harms the company's reputation or product. And I'm going to get into more details about what reputation means and what the other factors mean. This makes sense, and anecdotally, I think it is the most common kind of off-duty case where, sure, they showed up to work, they did their job just fine, but they've harmed our reputation by what they said or what they did outside of work. Number 2, the griever's behavior renders the employee unable to perform his duties satisfactorily. And I know that this isn't really about off-duty conduct because it's kind of saying that off-duty conduct can ground discipline if it affects your on-duty conduct, which also makes sense. Yeah. So, I mean, obviously, the communications roles are the easy example. If you're working in public relations and interacting with the media, and you need to have a foundation of trust where people can take what you're saying credibly, and where you're not going to be a distraction as well to the company, where if you're doing a press conference or talking to journalists, they're going to start asking you, well, what did you mean when you tweeted X? Obviously, that hinders their ability to do their job. It is harder to think of examples outside that context, I think. If you're stacking shelves or something, or you're in a custodial role, how a social media post is going to affect your ability to do that job, I think this is a more tenuous link there. Number 3, the griever's behavior leads to refusal, reluctance, or inability of the other employees to work with him. And so I mentioned this at the outset. And again, this makes sense that, I think there are sort of 2 main examples of where this might arise. One is if an employee starts making derogatory comments about specific coworkers in a public manner. Obviously, that's not going to be great for their employment relationships. Or if they just make generally racist, homophobic, sexist, etc. comments, how are their coworkers going to feel about coming into work with that person every day? Number 4, the griever is being guilty of a serious breach of the criminal code, rendering his conduct damaging to the general reputation of the company and its employees. So again, this is sort of similar to the first point. Reputation, again, it's about reputation, but maybe signals that criminal conduct is placed in a different category.
With respect to the reputation, does the employer have to show how the reputation has been damaged in some way? Do they have to say and link certain facts with she did this and now look at what happened?
I mean, it certainly helps if they can, but the short answer is that they don't actually have to establish specific harm. They don't, let me rewind. If it's a public comment, they don't need to say, look, this person has 1,000 Facebook followers, or their blog gets 10,000 hits every day. If it's, and there's some mixed decisions on this, but as a general rule, if something is public, Twitter, Facebook, a website, then the employee doesn't need to wait for a canceled contract or something. Assuming that the comment is on the face of it reasonably likely to affect the reputation, they don't need to be able to link it to a specific loss of customers, loss of contracts, anything like that, if it's public. But if nothing has happened yet, then there is a chance to remedy it, because assuming that the post is improper, then maybe it can be taken down and an apology goes up, and that would be a mitigating circumstance, especially if it hasn't resulted in harm yet. But the short answer is that no, they don't need to link it to a specific loss if on the face of the comment or the conduct it's something that a reasonable person would think it would make the public think less of the company.
So do they have to prove in some way, or more than just suggest that, yes, this comment, not only does the company disagree with the content, even though on its face value it might be, someone's perfect right of freedom of speech or whatever, but it has to be shown that by and large society would disagree with this kind of comment. You know what I mean?
Yeah, well, I mean, this is the type of...
One example where it comes up a lot is when employees are accused and sometimes convicted of, say, sexual misconduct or sexual assault. There's a court case out of Waterloo, and the name of it's escaping me, but the court basically said, look, obviously, right, this would harm the reputation of the company. So, I mean, do they need to prove it? Yeah, they always need to prove it, but what level of proof will it be? Depending on the facts, it will be lower the more serious the misconduct is. They're not going to make the employer put forth data about in the universities, like enrollment numbers or something like that, to say, well, enrollment must have gone down because this guy said something. Or, in a more profit-driven company, they're not going to have to show that the profit numbers went down. Right. It's sort of a gut test of, yeah, that's probably going to harm their reputation. So it's up and down.
And further to that, especially if the comment is sort of counter to human rights code protected grounds, like arbitrators are going to find it very easy to say that certain comments, and obviously this will be an issue in some cases. Well, what did they mean by that? Is there some ambiguity? Were they just being sarcastic or ironic? But there will be certain comments that are just clearly racist, sexist, etc. And you don't need any evidence on those clear-cut cases. And then even when it's less clear-cut, it's not really going to be a factual question. It's just going to be lawyers making arguments about, well, you could read it this way, you could read it that way. But, and I'm going to get to another case shortly. I'm going to get to another case shortly that actually goes to that issue. So number 5 of the Millhaven factors is if the griever's conduct places difficulty in the way of the, and you're probably noticing that there's some repetition here, in the way of the company properly carrying out its function of efficiently managing its workplace and directing its workers. And so one issue that comes to mind on this is maybe insubordination. Sometimes employers say that all these Facebook comments or Twitter comments saying mean things about a manager. I can't take my manager seriously. They're terrible. They don't know what they're doing. I mean, something like that's not going to result in termination, obviously, but those types of comments that are targeted at coworkers, targeted at managers, that are, they're not just a factual statement saying, my manager made me come in at this time of the morning, but my manager is a bad person. That's the type of thing that an employer will say, well, that's, whether or not it's in subordination, it's the type of thing that hinders its ability to manage the workplace. So these are factors to consider in general terms. And so now I'm going to go to a specific case that actually does get into the questions of showing harm or not showing harm, and just how offensive are these comments in the light of what the business does. So one of the most famous cases regarding off-duty conduct, I don't know if anyone's heard of this, is a case called Wasaya, I hope I'm saying it right, Wasaya Airways and the Airline Pilots Association from 2010. This airline was owned by a First Nations group, and it served primarily First Nations communities. Most of its clients, its customers, were First Nations individuals. And a pilot for the airline made disparaging comments about First Nations people on his Facebook page. And I don't think there was any dispute, going to your question, that the comments were inappropriate. I don't actually have the specific comments, but everyone kind of accepted, yeah, these are not appropriate things to be saying. And further, the airline statement of values, which was provided to all employees, really emphasized the significance of its relationship to First Nations communities. And this doesn't mean that, well, if a business isn't actually specifically focused on a certain group, then it's okay to be racist, but it does mean that maybe more severe discipline is warranted depending on the communities served by the business. That instead of a one-day suspension, maybe it's going to be longer. Maybe it sort of ups the ante in terms of how the employer can respond. And so the Grievers Facebook post, I'm not clear on what the privacy settings were. I don't think this was a post that circulated. Well, it wasn't actually. It wasn't a post that got picked up by media or anything. But it had been seen by an employee of a significant client of the airline, some sort of company that always booked flights with the airline. And it had been seen by an employee of a rival airline, and it had been shared a couple of times by other individuals on their Facebook page. It was literally a couple, I think. There was only 2 other individuals. But the media hadn't picked it up. So again, going to the question of does it have to be harm? The media didn't know about it. Just one client maybe knew about it. But the company was understandably afraid that this would turn into a public relations disaster for it, obviously. And it terminated the Grievers' employment. And the union grieved, the Pilots Association, and the arbitrator ultimately reduced the penalty, said that termination was an excessive penalty, but substituted it for a 4-month suspension, which is still quite a significant disciplinary reaction. 4 months is a long time.
Was that time served?
I actually don't know the timing between. I assume if it was 4 months total, so if it had taken a year to get to arbitration and so forth, it would have been back paid for 8 months, but I don't know the timelines. The union, in its grievance and in the arbitration, had argued that termination was too severe because he apologized. It was an isolated incident. This pilot wasn't known for generally being racist. There wasn't a long history of other comments. When they talked to his coworkers and did the investigation, they didn't find any other incidents in his past. So at least at that time, it was an isolated incident. He had mid-length service. The airline did not have a social media policy. That's a significant point. Again, this was 2010, so feels like just yesterday, but that's 8 years ago now. And Facebook, I don't even know if Twitter was around then. Facebook was still relatively new. I don't think many companies had social media policies. Often they do now. And that's going to be a significant question in terms of any discipline about whether the company has made its employees aware of whether it has any expectations about use of Twitter, Facebook, etc., public comments. And if it hasn't, depending on the severity of the off-duty conduct, then that's going to be a pretty significant point in challenging any discipline.
Jump in first.
Sorry?
Can I jump in?
Yeah.
What I've been noticing is that, like, much like marijuana, we're dealing with this sort of getting to know you phase of social media. And so, back even when I was in university, if I was mad at work, I worked at York, by the way. If I was mad at work,
Sorry about that.
I would go. I was excluded work study student. I'm not supposed to tell you that. If I was mad at work, I'd go to one of the pubs with my friends and grab a beer and say, "God damn, my boss, he's driving me crazy. I can't stand him. He's always bugging me," whatever it was, right? You have those conversations, and those conversations were fun. And then you enter this world of social media, and people are continuing to have those conversations. And they're having them, unfortunately, more and more in public. And part of me says, don't be so stupid. Don't talk about your boss on your Facebook account when 3 other managers are on your friends list. The other part of me says, like, when are you going to get the outlet? And so most of the case law in the arbitration world does come around these comments made about managers on social media. And sometimes I think they just need to get a bit thicker skin. I mean, I'm sure Brett complains about me and the other partners at the firm all the time.
I haven't received any warnings about my Twitter account yet.
And it is like, we're talking about a case from 2010. I'm not justifying it. Like, it was in Westewas, it was very it was racist comments about customers. I would never stand up and sort of justify it. But a lot of the cases are complaints about managers and whatnot related to the workplace. And the early case law, when I say early, like, I'm talking like 2010, compared to sort of some of the more recent case laws sort of saying, like, no, this is sort of more like going and having a beer with your buddies. Now, there still seem to be disciplining people for it, but it's an evolution of sort of understanding what this technology is, understanding how people are using it, and understanding, like, does this really matter at the end of the day if a lower level employee is making comments to 50 other people that are their friends about how difficult their day was. So anyway.
Are you always considered an employee? Like, can an argument be made for things that are done on breaks, lunch, after work?
Well, that was what it used to be, right? It used to be, when I'm at work, I do my job, and when I'm not at work, I can do whatever the hell I want to do, and it's none of your business. And to be honest, some of the creeping into the social lives has been based in really good reasons. It's the classic bad facts make bad law. So a lot of the case law has to do with sexual harassment that happens by managers to employees, but not at work. And so there's cases where the manager invites a bunch of employees to the cottage and starts to act completely inappropriately. And so we have to react to that. No one here is going to put up with that type of sexual harassment. And it's not really going to work for us to come up and do a grievance and say, but it was at the cottage. No, it's still bad. But the problem we're seeing now is that with social media, with it being so public, a a lot of arbitrators will see something like Facebook and they'll get spooked because back in the olden days, like in 2000, broadcasters, you needed a broadcasting license, or you needed, a huge printing press to have as many eyes on what you were saying about somebody when you're, kind of exercising these free speech rights we like to play with. So now, when the earlier cases, arbitrators are saying, well, whoa, anybody can read what they're saying about the workplace in their Facebook post. This could go to millions and millions of people. It's available for everyone to see. And their profile says they're an employee of Dewart Gleason. So, oh my gosh, it's just horrible. Your Twitter feed with 120 followers is not CBC in the 1960s with half the nation watching you. So we're fumbling around with this right now, and there's a lot of it's going to take 10 years to figure it all out. That said, it can be very difficult for us when we're dealing with these things because there's certain things you don't want to justify either. Yeah. Anyway, thank you.
And a similar point as well, and we'll get to this, is that arbitrators often look at, well, what were the privacy settings? Right? I mean, is this a private Facebook page that only friends and family are reading? Or is it a public Facebook page that anyone in the world who searches, with the Dewart Gleason example on Facebook, will see this page and then be able to read these comments? Or is it a public Twitter account? Is it a private forum that you made? And these are all questions that are going to be relevant for assessing the significance of the comments for the employment relationship. Is it something you could reasonably expect to become public in a significant way?
Well, it's not that different from the pub conversation that Chris was talking about, where you've got maybe 8 people sitting around a table, and those 8 people could tell 8 other people.
Yeah.
On Facebook, it's one account in billions.
Yeah.
Where no one might ever look at it, or the people, they don't care.
Mm-hmm.
The internet is so vast that it's one person. I can understand, it depends on the egregiousness of what the individual says, I guess. And it can, like a Twitter feed, just go viral. But it's really difficult to,
Well, I mean, there's a certain kind of unfairness about it as well. When you think of that first example of Justine Sacco, 120 Twitter followers, yes, it was a dumb thing to say. And again, there wasn't really any evidence to suggest that she, and again, that this was part of a chain of inappropriate comments or anything. It was just something she was about to get on a flight, said something stupid, and if anything, there was a lot of commentary about this, about how we should interpret the tweet, right? That some people are saying, well, she was making an ironic comment about her privilege and stuff like that, and when it gets blown up and taken out of context, then that goes missing. So there is an unfairness there, for sure.
I was reading that there was a case a couple of weeks ago in BC where this bride wasn't very thrilled with the pictures from her wedding and expressed or vented, and the photographer took her to court and won $100,000 and something as damages. So it's you can vent, you can get upset, and I don't know how many followers this individual had.
Yeah.
But the courts rule that, you damaged the...
Well, yeah, and I mean, then that starts to veer into just general defamation law.
In that case Julia was talking about, and I actually read the whole thing. She was relentless. It was on every place she could badmouth, she did. And she might as well taken out the whole page ad and then threw her son. She was absolutely the same problem. And she was asked to remove it several times. She didn't remove anything. And that's when they finally took it to court and said, hey, you can't judge it.
Yeah.
And the judge did award them $115,000.
Yeah, I mean, I don't know the specific facts of that case, but it makes a big difference about whether it's true or not. I don't know what exactly she was posting, but is fair enough to leave a bad review on a company website. We're obviously getting a bit away from the employment context, but people do have free speech rights. You're allowed to complain about managers and complain about bad service at a restaurant and bad photography, but there are reasonable limits on how you do that, and if it's untrue, if it's if it meets the legal test for defamation, there are restrictions. That's the take.
So, if we have a member is having troubles with their coworker, Facebook page, venting, not mentioning any names, but I don't understand why they're going out of their way to try and get me fired. My manager. This has been going on not just for weeks and months, but through a consecutive number of managers, right? I don't know what to do. My managers don't seem to be doing anything about it. The next thing you know, she's called into a meeting and they're printing off her comments. Right? Saying, this is inappropriate. Privacy settings locked right down, right? Don't know how they got them, refused to tell us how they got them, right? And said, well, how do you think I feel as a manager reading this? Really, but like, what is the privacy, like, the privacy implications about that? It was just like, to a friend, I'm having a really bad time at work. I don't know what to do with it. My manager doesn't seem to be doing anything about it. Like, what is our recourse for that? I mean, it wasn't a disciplinary meeting, but could have been.
I mean, it is a pretty fact-specific kind of situation, because obviously, say someone's secretly recording a conversation that you have in a living room with a friend, and then they take it to the manager, and they're like, he was bad-mouthing you, and I went over for drinks afterward, right? That's kind of the analogy that I think of when you have if it is actually a locked down, fully private Facebook page, and then a Facebook friend then takes those comments. I think you've got a strong argument that...
Yeah, it's really unfortunate. I think, it sounds like kind of, there's usually with those situations something else going on between whoever disclosed it to management and her. And, in terms of legal recourse, I'm not going to sit here and suggest that, hey, let's file a grievance and say it's a breach of privacy and stuff, and that's going to lead to much justice. But it sort of brings up, is there something else going on in this particular workplace? What are the relationships looking like? And do we need to sit down and have a discussion about why the knives are all out?
And when you're trying to establish...
Because that came from a discussion you brought up with the manager originally, saying, there's problems in the workplace here. I don't know what started them. Can we, sit down as a department and try and figure it out? And the next thing you know, here we come, well, here's your Facebook page. No wonder there's problems in the department. Do you think this is appropriate? Right?
Yeah, sorry, my eyes just went all the way back in my head. Usually when there's a problem, people complain about it, and more we're seeing people complaining about it on Facebook and Twitter and all that. So
almost like a diary.
Yeah, well, that's what people are using it for.
And if you can't vent to your friends, who do you vent to, right?
Yeah. Unfortunately for us, we have to be telling the members a lot of the time to, cool it.
So would you have the same comments in the union Facebook page and its members?
Well, that's a juicy one, right? Because you mean like the union's own communication with their members, and the employer wants to get into it?
And they open it up for their members to play with. Right?
I've seen those get pretty poisoned too, but is the employer, like in situations with the employers, it's not the employer's business.
No, I'm not. I'm just taking it the other way. I'm taking it from the union side.
Yeah.
And its members posting maybe inappropriate things about other members, not for the workplace, like the union. I know there's remedies that there is for staff and others, right, that go down that. But I'm just interested there would be the same facts, same thoughts around the union Facebook pages versus Facebook page.
Well, if it's the employer interfering and trying to use the stuff in the union's private Facebook page and somehow getting their hands on that and trying to use it against us, there might be facts around whether that's an unfair labor practice or not. It wouldn't be one that I'd be like rearing to the labor board to get at, because it doesn't look good for whatever union it is. But the member on member stuff, yeah, yeah, the member on member stuff's just always difficult, right? Yeah, and make the decisions when it gets like that, just what to do. It's freedom of speech is a really interesting concept when it comes to whether the government can limit our ability to speak freely and create laws that limit those abilities. But it's a little bit different when it comes to our own private regulation of what our members should be saying to our other members. And there's nothing wrong, legally at least, with the union saying, no, we're shutting this down. We're moderating this. This is not appropriate. And most unions, and I know the CCU has policies around harassment internally, and those things might get triggered in those incidents, and members should be reminded of those policies, and it's not something we put up with.
If we have those remedies, we just look at the union Facebook.
Yeah.
There's pros and cons in the conversation, so that's what I've been asking.
Yeah. The toxicity of online discussions is an issue that's going to happen with unions. Yesterday, Twitter was, announcing that they need to reprogram because clearly there's so much harassment going on in that platform that they finally are pretending to look at it. Maybe we should edit that out. No, they're saying they're going to look at it. I just don't know what the solution is. Right, and the same people that get targeted in our society generally are getting targeted more and more, mainly women, are being targeted on these platforms. So it's really easy to say insulting things if it's with the shield of anonymity. Right?
I just wanted to respond, I don't want to be sorry, but as an administrator on a Facebook page or group, you can monitor comments. Yeah, so they can be high, medium, low, and if a word comes up that they can target that word, and it won't show up unless the administrator allows it to be posted. So there's a little bit of control there.
Yeah, I mean, you need to just decide how many resources you want to. Like, I don't know how active this Facebook page is. It's just a couple of posts a day, or dozens, or maybe there's silence for a week, and then something comes up, and then hundreds of people are commenting.
Case, the union totally. The harasser was a member of its. I can't remember if it's executive. It was a steward, and the union decided it wasn't going to proceed with the harassment grievance and just said, no, our interest to our steward and the discipline he received outweighs your harassment issue. And the victims took him to, I believe, the Federal Labor Board, and the board hit them pretty bad, saying you didn't take their interests into consideration, and you favor the interest of your own and pursuing this discipline grievance. So that's something you want to avoid. The thing to remember in these circumstances is the employer can violate the collective agreement twice in the same set of facts. There are circumstances where our members do things that are improper, but often the response, the disciplinary response of, say, a termination, is still too far. So you end up in the discipline case, maybe not saying the harassment didn't happen, but saying harassment did happen, but the termination is too much. This person shouldn't lose their employment because of it. And in the other case, you're saying, employer, you still didn't do enough about it to prevent it and to create an environment that's free of this type of misconduct. It's something that's very difficult and something you always want to go hire people like us to try to navigate you through. It's not a advertisement. It's a really fraught circumstance, and it's fraught for everyone. So that's kind of it in terms of my comments on DFR responsibility. Does anyone have any questions, or is everyone just thinking about getting up to the hospitality suite?
No, look at it.
I don't blame you. Yes.
I just wanted to comment quickly on your last thing. We have sort of the luxury in our union of having a couple of people that deal with labor relations matters. Mm-hmm. So whenever we get the first inkling that it's a member against a member, a situation like that, we automatically divide we say you deal with the one party and you deal with the other party. So that's a good way of approaching it too, so that you can have a clean approach to each situation without one interfering in the other.
Yeah, and you have to be careful about how the information gets passed,
Yeah.
right?
Yeah.
And it's also really important to explain to grievers just the extent to which the confidentiality is limited. It's not perfect. And when you're representing, often it's about being transparent. So I said before, it's about how you do it as much as what you do, and making sure that they understand, you've separated the representation. Both of us are going to have to report to the executive about what's going on. If you tell me things in confidence, I'm not going to share them with the other member, but there are certain people that are going to learn about that. So it's a really difficult situation to navigate, but that's the kind of best practice is to separate the representation. I think most of the unions here are big enough that they're able to do that. Some of the smaller locals, it becomes a lot more difficult. But usually the equivalent of the CCU or something would get involved to help navigate those kind of fraught problems.
So what happens if you try to separate the two and somehow it gets muddled and all of a sudden the one steward got information that they weren't supposed to get versus the other? What's the best way to fix that with the member?
Well, depending on the circumstances, it's not usually that it's the stewards getting information that's the problem. It's usually the harasser getting information about the complainant or vice versa. And so sometimes you just have to, contain that. Many of you may have been in arbitration proceedings where the arbitrator will say, look, I'm going to mediate this dispute, and people are going to say things in mediation, but when you get to the hearing part, I can't consider what's said in mediation. I can only consider what the evidence is. And it's not unreasonable for somebody to say, yeah, you know what, I got this information as a result of a leak. You're not going to share that with the member you represent, but you can still continue to represent them. It depends on the nature of what's been leaked and the lack of confidence that it may have caused. But there's ways to navigate that, just practically.
Is there another question?
I'm okay.
You okay? You got that? Any other questions? Well, I want to thank both Chris and Brett, for taking the time off on a busy Saturday. Thank you very much. This is a great presentation.